because right is still right, even if you stand by yourself.
Welcome to Case in Point, the legal show for regular people. It is Thursday, January 16th. I am, as always, your host, Sarah Parshall Perry, a senior legal fellow here at the Heritage Foundation in Washington, D.C., but I am a regular lawyer talking to you, regular people, eliminating Washington newspeak on everything from the law to executive orders and helping you understand why the law matters in your life. There is lots of legal news to cover before we actually get to our program today with two of my fellow legal fellows here at the Heritage Foundation on two very high-profile cases that were just heard at the Supreme Court. What were their impressions of oral arguments? Before we get to that first, let me tell you, it's the most wonderful time of the year. Not Christmas, not New Year's. Oh, no, it's inauguration season. We have started to hear confirmation hearings on Capitol Hill for a number of incoming President Trump's cabinet nominees, all 15 of them. Pam Bondi was actually questioned yesterday, and Pete Hegseth faced some pretty significant grilling in the Senate as well. Doug Burgum, Tulsi Gabbard, those nominations have been postponed. They need to apparently have their background checks completed. So it's likely, in fact, virtually guaranteed that the president will not start this term with a full cabinet. Now, last time around, he didn't have a full cabinet until the end of April in 2017. And that's simply cabinet secretaries. We are likely to see hiring and promotion ongoing for many, many months, in some cases as many as a year or two for some of these secondary positions, deputy secretary, assistant secretary, lower level council positions, advisors. So this is going to be an ongoing process, but if the fireworks in the Senate were any indication of how highly contentious these hearings are going to be and how hard these nominees are going to have to work to actually get to these posts, I think it's a good one. So, Title IX, of course, an issue we've talked about here on Case in Point, the simple non-discrimination law dating to 1972 that prevents sex discrimination in any federally funded education program. As you know, the Biden administration has issued a rule expanding sex to include gender identity and upending women's civil rights law and equality in education for many, many years to come. That is, of course, until an opinion we just received on January 9th from the Eastern District of Kentucky. Judge Danny Reeves, who is a stalwart textualist interpreter of federal law, meaning he goes by the book and by the law's words themselves, actually struck down the entirety of the rule, granting what's called summary judgment for the petitioners, for the plaintiffs, meaning that the case needed to go no farther. He had enough evidence before him to make a ruling that the Title IX rule from Biden was illegal, not only unconstitutional, but also a violation of civil rights law and administrative law. What he did was vacate or set aside the rule as if it had never been issued at all. And that means until the Sixth Circuit or the Supreme Court weighs in, we are looking at a very good back to status quo outcome for every female student in America. So good news. But we've just heard oral arguments in two cases. One's TikTok versus Garland. The question is, can the federal legislative body, can Congress restrict online platforms in such a way that potentially burdens their speech if they have a national security interest involved? That was the question at issue in TikTok versus Garland, which was just heard on January 12th. Now, those particular arguments were represented on behalf of TikTok to include claims of the fact that they are not, in fact, a United States company, or a Chinese company, rather. They are a United States corporation, when in fact, as many of the justices pointed out, that United States corporation, through a series of other corporations, is actually owned by China. And China, as we know, is hostile to American interests. So what will prevail? The First Amendment or national security? Two huge questions that we're going to discuss today on Case in Point. In the second case, on January 15th, on Wednesday, we just heard oral arguments in what is certainly one of the most high-profile, if not one of the marquee cases of the Supreme Court term, and that is Free Speech Coalition versus Paxton. Now, it's not exactly a, quote, free speech coalition in the traditional sense. These are a group of pornographers and one anonymous porn star. Not exactly your stalwart constitutional advocates, but here, they do not want the state of Texas restricting access to their online porn content by requiring age verification. Well, Texas requires age verification and passed a law requiring just that, specifically because they don't want minors under the age of 18 accessing hardcore porn online. Now, you'll have a state's interest in protecting minors, obviously a compelling interest, up against the First Amendment claims of porn providers. Who will win in that case? Well, we discuss oral arguments today on Case in Point. I am really excited to be joined by two of my favorite people. We've actually had a really good laugh before the camera started rolling in the pod studio. Jack Fitzhenry and GianCarlo Canaparo, who are senior legal fellows with me in the Meese Center. And I like to call them the nerd duo because they are so smart and they write such compelling work and they're really brainiacs. We were joking that, they're very erudite lawyers, and I like to joke I'm just a small town pizza lawyer. So that from an old Little Caesars commercial for those of you old enough to remember it. So Jack, GianCarlo, welcome.
Thank you for having us.
Thank you.
All right. So we have heard oral arguments in what promised to be two of the biggest cases in potentially the entire term. And they were just heard within 5 days of each other. So we heard a case, TikTok versus Garland, specifically related to regulation of a social media app within the United States and its implications for the First Amendment. And then we also just heard yesterday, on Wednesday, oral arguments in the Free Speech Coalition versus Paxton case. Can a state legislate in such a way as to require online verification of age for access to porn within its boundaries without running afoul of the First Amendment? So two tech platforms, two First Amendment questions, very different formats. I want to go to TikTok versus Garland first, and I want to talk about the law at issue and essentially break down that question for whether or not a foreign adversary, right, a country like China that is distinctly hostile to United States interests, can be forced to divest its tech apps in the U.S. as a legitimate exercise of national security power. So tell me a little bit about this law that Congress passed.
Sure. So the law at issue was a bipartisan concern. It was actually a by-administration concern, or at least TikTok was. During the first Trump administration, there were some executive actions that aimed at sort of neutralizing the national security risk posed by TikTok's ownership. And maybe it's best that we make that somewhat explicit, what that ownership is. It's a little complicated, but I think the clearest way to trace it is to say that TikTok, which is technically a U.S. company, is owned by a parent entity through a variety of shells. The parent entity is called ByteDance. ByteDance is located in Beijing. It is subject to Chinese laws. It has within its own corporate organization, a committee of the Chinese Communist Party, and the allegations are that it is directly answerable to the governing body of the Chinese Communist Party. So that's a sort of simplified tracing of the kind of ownership giving rise to the national security concerns that have, again, interested both the first Trump administration, the Biden administration, and perhaps most importantly, a large bipartisan majority of Congress, right? We're so accustomed these days to having all policy done via executive order, executive action. That was how the first Trump administration tried to approach the problem initially. When that got bogged down in court, sort of like force them to do the right thing and go to Congress to legislate. And you got bipartisan majorities in both houses to support this law. And this law, it's sort of hinges on the designation of China as a foreign adversary. Right? The law is always spoken of as though it addresses only one company. It's actually written broadly enough to address companies that might find themselves in the control or in the thrall of other foreign adversaries. It's just that at present, the best, if not only, example of such a company is TikTok. And so it's been the one subject to enforcement. And yes, they required TikTok to required ByteDance to divest itself of TikTok within 120 days. That leaves us with a deadline that's still in place of Sunday, January 19th.
Yeah, which is coming up the day before the inauguration.
Rapidly. And in the meantime, we've had a D.C. Circuit decision that was unanimous as to the result. They unanimously upheld the law. It was 2-1 split on the reasoning. Two judges, including Judge Van Dyke, who's a Republican appointee, said this law needs to be subject to the strictest, highest level of scrutiny because it does implicate First Amendment concerns, or at least we're going to assume that it does.
Sure.
But even under that highest standard of scrutiny, it passes muster.
Yeah.
The one concurrence, partial dissent, said, I don't think this requires the highest level of scrutiny because it doesn't really implicate First Amendment concerns. Nonetheless, I agree, we uphold the law. So that got up to the Supreme Court on a highly expedited basis. Again, heard oral argument in that last week. I think it was Friday that the court heard oral argument. I mean, that's lightning quick. But oddly enough, even with the deadline approaching, we thought maybe we would get a truncated opinion in it today, given that the deadline is coming up, given that the court promised that today was going to be an opinion day, and it did release 2 opinions, though not consequential ones.
Yeah.
So we'll see if the court may still intervene to stay the law. That's a possibility that I think all sides conceded during oral argument. But it's not inevitable, so the clock is running out.
Yeah, well, it seems to me, based on what we recently heard in the news about TikTok preparing to eliminate itself from American platforms, they may have read the tea leaves on this, at least as to a majority of the justices being very supportive of government interests in protecting us from national security issues, from preventing hostile actors, from using the type of data that we know TikTok harvests and maintains and manipulates. And that's actually one of the things that the government's lawyer, Solicitor General Elizabeth Prelogar, mentioned. It wasn't just the taking of data, it was the manipulation of data and the nefarious use of data. I thought that was very interesting. She talked about specific use of the data to gin up conflict between users, which was something I think that surprised me. So this law would seem to be very common sense. So in the same way that China is considered a foreign adversary of the United States, Iran, North Korea, nations that are patently hostile to American interests, would clearly be on that precise list. We have never recognized a First Amendment right for foreign entities within the United States. That's actually something I believe that Justice Elena Kagan brought up. Is that something that you think the justices should have paid more attention to? Because even though it's through a series of sort of corporate structural manipulations and it's owned and owned and owned, but eventually traces back to the CCP, which is incredibly problematic. Should we start the analysis and end the analysis with, listen, TikTok doesn't really have free speech rights in the United States to begin with?
Yeah, so it's an interesting facet of the case. I think the court gave it due attention. They're clearly aware of it. You're right that Justice Kagan was the one who asked the most pointed and frequent questions in that vein. And the essential thrust of her argument or her concern is that foreign actors abroad, I guess we have to be kind of careful about this, but foreign actors abroad do not necessarily enjoy First Amendment rights, which should make a lot of sense.
Right.
When they enter the United States, when they're physically present here, the picture might get murkier. But I think on one end of the spectrum, we're relatively comfortable saying that foreign entities abroad simply don't have First Amendment rights. But here we have a corporate structure where the clean division between foreign and domestic has been blurred, probably by design. And it's also one of those complications that should make one a little bit uncomfortable in saying that TikTok enjoys no First Amendment rights, because TikTok, as I said at the outset, is technically a U.S. incorporated entity.
Yeah.
I believe it's Delaware. I mean, that's a safe assumption, but it's a U.S. incorporated entity. It's here physically. It has offices, employees, and the like. in some ways, it is trying to pass itself off as every bit as American as Facebook or TikTok. And the picture just frankly isn't that clear. But then the question becomes whose speech rights, whether they're truly First Amendment protected or not, whose speech rights are actually being burdened here? Is the law really affecting TikToks directly, or is it really affecting bike dances directly?
Yeah.
And if it affects bike dances directly and affects TikToks only incidentally, then we probably have less of a constitutional issue.
Yeah.
The data privacy thing or the data gathering thing is sort of a separate security issue, and one where I think the government's on firmer footing. That might even suffice by itself to uphold the law. But the court is clearly interested in probing the margins of the First Amendment issue here. So I think that's where Justice Kagan's questions come in. Again, former Solicitor General Noel Francisco was the one arguing on behalf of TikTok, interestingly enough.
And ably, I would say. I mean, he did a tremendous job.
He fought the good fight. He did not have an easy go of it. It was not a light day at the office. The man took a certain beating, not because he was doing a poor job, but he was meeting with some skeptical responses. I think it's tough when you're the petitioner. It's tough when you're going first.
Yeah.
And the justices, it's like a boxing match where your opponent has kind of exhausted themselves, using up all their punches on the first few rounds. By the time Jeff Fisher from O'Melveny, he gets up there and argues for the creators, the justices are maybe a little tired, a little sleepy. They've gone through a lot of the themes that they're interested in.
Right.
And then finally, by the time Solicitor General Prelogar gets up there, the bench is almost comatose. It's an exaggeration. They gave her a bit of a rough going too.
Yeah.
So if I was ByteDance or if I was TikTok, I wouldn't necessarily look at that argument and say that there was a clear tendency one way or another. I think out of today's oral arguments for the porn age verification case, we've probably got clear tendencies. But for the TikTok case, I thought they gave both sides a pretty hard time. I did too.
I'm curious as to what you both make of Justice Gorsuch's response in the sort of the back and forth, a colloquy with Elizabeth Prelogar, arguing for the Department of Justice, that the government's view of protecting Americans from foreign propaganda was kind of what he called a paternalistic point of view. Why isn't the remedy, he asked, for bad speech more speech? In other words, why would this stand constitutional muster if the internet technology, the platforms are so ubiquitous and so expansive, you could just offer alternatives through another route? What do you both make of that? GC, you first.
I think that line of criticism exposes the danger of treating this like a free speech case and not a national security case.
Yeah.
Right? Because that is, if the concern is misinformation or whatnot, somebody like Justice Gorsuch is immediately going to think, we just watched in the Murthy case, and we had a case where the federal government was, censoring as misinformation any criticism of its vaccine policy, for instance, or its lockdown policy. And I share those concerns. I think that the government would have been wiser to really make this a national security case instead. But, I guess, if you're the government, you've got 9 justices. You throw the spaghetti at the wall, make the best arguments you can with both. Because, again, turn to the pornography case today, and you see, Justice Sotomayor and Justice Jackson going to the mat for pornographers.
Yes.
So,
yes.
You want to cover all your bases.
That's exactly it. But, I think Elizabeth Prelogar, who was arguing for the government, got to that point at the end of the arguments, because her last sort of interplay with the justices was, it's not a data mining issue, it's not a content restriction, it's a national security issue. That was really sort of the cherry on top for her. If the government, I think, had led with that or had structured their arguments in such a way that it was national security and the jurisprudence on national security and the fact that free speech, if ever implicated within the concept of national security, has been routinely upheld. We know the Supreme Court recognizes free speech is not a free-for-all, right? So we recognize restrictions, and GianCarlo and I talked about this in last week's Case in Point, but the government has restricted speech in other contexts, right? Incitement of violence, speech in furtherance of a criminal enterprise, child pornography. There are restrictions that they've recognized for 60, 70, 80 years, this to me would seem to be a relatively easy case from the standpoint that national security should be one of those interests. So, Jack, what is your sense? And it's always hard to kind of guess on these things. And our boss doesn't like it, and he listens to the show. So, John, I feel you, but I'm going to ask anyway. What are your impressions? Jack, you first, and then GianCarlo, I want to ask you. What are your impressions from oral arguments as to how this could go?
For TikTok?
TikTok, and then we'll get to porn regulation, but that's after TikTok.
I'm still relatively sanguine that the law will be upheld and the government will prevail in this case.
Yeah.
I think it's important to take account for where the case stood when it reached the Supreme Court, and that was again 3-0 in favor of upholding it in the lower court, and the lower court, we should keep in mind, was adamant that national security was the justification and a perfectly adequate basis. And it said this, again, Judge Van Dyke said, this may well be subject to the highest level of scrutiny, and even still, it would pass muster.
Yeah.
And I think that was kind of an important background assumption. It may be that oral argument, which was contentious and difficult for most of the advocates, it may be that was almost a kind of kabuki theater, a chance for the justices to kind of air their First Amendment concerns against the backdrop understanding of the national security concerns.
Right.
It may be why national security was not raised quite as frequently as one might have expected. It may be why it took an hour and 40 minutes before somebody even acknowledged the possibility that, hey, this could be strict scrutiny and the government would still win, which is exactly what the lower court held. Maybe that's why it was left unstated for so long. And, I think recent free speech jurisprudence has just been so reflexively libertarian from the court that it's not at all surprising to see the platform raising these types of challenges. It's not at all surprising that the justices find themselves in an awkward position of trying to, make peace with some of their past decisions and the tension or the tense place that might put them in when important interests like national security come up, or when defense of childhood innocence comes up. So I'm still relatively sanguine that on national security grounds, the government will ultimately prevail here. But it's not a given. They've been treating expressive rights as increasingly absolute.
Yeah.
And so I certainly wasn't shocked to hear them spend a lot of time, mulling those over.
Yeah. I think it's interesting that because of the nature of evolving technology too, we have not one but 2 cases just this term that question things like access, because this is where the majority of people get their news is on online sources. And we know it plays disproportionately with minors who don't have a concept of data manipulation or algorithmic alteration or, sort of geometric data that's being plumbed. I can tell you, my kids all use TikTok. They have no concept of this. And when I tell them this is a platform that is ultimately owned by a communist Chinese entity, it presents real concerns for people in the U.S. They're like, Mom, please don't ban TikTok. Now, they don't understand I have no authority to ban or not ban TikTok, and I am only a lawyer that writes about these issues nevertheless. GianCarlo, what were your impressions from TikTok?
Yeah, I think Jack's exactly right. But there's an interesting, free speech concern animating both cases. This came up a lot in the pornography case today, where the justices, Justice Barrett and Justice Kagan in particular, were like, okay, part of the argument in the porn case also is like, should this kind of age verification for pornographic websites get the highest level of judicial scrutiny?
Right.
And if it does, can the state still win, just like maybe the federal government still wins in TikTok? And Justice Barrett said, look, historically, when we give something strict scrutiny, it's the famous phrase is strict in theory, fatal in fact. If something gets strict scrutiny, that just means the government can't do anything.
Right.
And so if we hold that strict scrutiny applies in both these cases, but that the state gets to do it anyway, have we weakened strict scrutiny? Have we actually made it like, strict in theory and strict in fact?
Strictish.
Yeah. Strictish, right? And, Justice Kagan sort of expressed sort of the abstract, not particularly applied, but sort of abstract concern. Like if we do that here, will we do it elsewhere? And will there be a slippery slope towards moral government regulation of speech where it's not so clear? I think the porn case presents a really bright line where that's not really a risk. Because like the government said in the pornography case, pornography is like really unique in that everybody agrees that there are two rules, one for minors and one for adults. And you can draw that line really easy. It's pornography and nothing else. And, the TikTok case, national security, there's a foreign company, under the control of a hostile power. Like you can draw these lines, but obviously the justices are concerned that, maybe those lines look really clear now, but,
could be muddy in the future.
Could be muddy in the future. And again, constantly in the pornography case, the state was running into really bad case law for it. I mean, like Jack said, the court's obscenity jurisprudence has just been reflexively hard libertarian. Like we talked about when I came on a couple weeks ago to talk about this case. I mean, of course it is, right? Because the Supreme Court made itself the arbiter of all free speech questions.
Yeah.
And if you're trying to do that for the entire country, what other rule could you possibly pick? But it's all protected.
Yeah.
Right? There's nothing you can do if
they
that's the rule.
They bound themselves to that
right.
kind of a view, which is super expansive, super protective.
Right.
So let's talk about the porn case, because I find this fascinating. In part because, as a mother of 3, 2 of whom are 18 and under, I've got real skin in sort of the question of, can a state restrict a minor's access to porn through the vehicle of using online age verification? And that was the Texas law at issue here. And the Texas law actually, and this actually made a very brief appearance, actually allows this Free Speech Coalition, which, by the way, is a bunch of pornographers. GC and I have made fun of the non-traditional nature of these, quote, free speech defenders. Guys, let's just be clear. Pornhub is one of the clients here, okay?
This was one of the surreal things listening to this kind of oral argument is if you are able to step away from your law degree for a moment, or if you don't have one, you
God
listen
bless.
to this. Yeah, well, God bless you. But you listen to this story. What just like the thought that just is constantly bouncing around in your head is everybody has just assumed, as easily as they assume that the sky will be blue tomorrow, that hardcore pornography is protected free speech. Like to anybody who isn't a lawyer, that must just be so super weird.
Yes.
But that is the world we're living in. And so you listen to these oral arguments, we're talking about strict scrutiny this and intermediate scrutiny that, and brick and mortar stores this and dial-up internet that, and you're like,
we're talking
but
about
is hardcore
porn.
Pornography protected free speech?
So that's
nobody asked that question.
This is so funny to me because I live tweeted the oral arguments, and you would not believe the number of people who are just everyday non-lawyers saying, "Oh, well, it's not protected. It's not free speech protected." And I'm like,
all the lawyers are like, oh, look at you, simpleton.
Unfortunately, I had to do like a brief jaunt down the court's obscenity jurisprudence. But you're exactly right. I think the first question is, and you've written about it, the whole obscenity jurisprudence is really due for an overhaul. We need to reassess the fact that, in some of the early obscenity cases, like Miller versus California, right, in 1973, we're dealing with a totally different animal right now. Not only...
Well, let me just say, Miller is early by sort of the modern jurisprudence standards. But
yeah.
We've got earlier jurisprudence.
Yes, we do.
And that paints a really wildly different picture than what the Supreme Court does now.
Totally different. Yeah. And in fact, one of those cases... So just to put the highlight on the issue, in the Free Speech versus Paxson case, the question is, what level of scrutiny applies to a law like the one that Texas passed? Is it strict scrutiny, all right, making it almost invariably presumptively unconstitutional, the highest bar for a state to have to get over? Or can you apply rational basis? Because the state's interest in protecting kids does not implicate that strict scrutiny analysis, right? So you've got two competing interests here. The Porn Coalition basically says, listen, you've got to apply strict scrutiny, and Texas can't satisfy strict scrutiny. It's too onerous a burden. It's a content-based regulation on speech. There have to be less burdensome ways of doing it. This is what I found fascinating. First of all, Alito made me laugh out loud, not once, not twice, but a couple of times in oral arguments, because one of the things he said was, the attorney for the Porn Coalition had basically said, listen, there could be less onerous restrictions, including, having parents regulate online porn access for minors within their home. Okay, listen, I've had teenagers in my home. I would tell you what, it's a lot harder to regulate them than you think. And Alito actually said, come on, you don't think any parent is more tech savvy than their 15-year-old? And he said, give me a break. I thought, yes, Justice Alito, I feel you. I think, the arguments that were being made in this particular case by the Porn Coalition were, they sounded to me as being a bit cyclical. And I think a lot of the dialogue, a lot of the questioning went back to, okay, how onerous is too onerous, right? If just getting to, by the way, pick your own pornographers, your own age verification provider through whatever means that is, you get to pick it. If that's too onerous, what would be less onerous? And that's when the hypothetical of, okay, well, they can restrict it in the home. I think that underestimates the tech-savvy nature of children, number one. And number two, the accessibility of pornography. I mean, it's free. It's everywhere. It's downloadable. It would seem to me, and I'm hoping that the court reads it this way. And I heard 5 or 6 justices who seemed to be inclined toward this, that in the end, a state has the right to restrict harmful conduct for minors. The Ginsburg case came up a lot. Mm-hmm. Talk to me, GC, a little bit about the applicability of Ginsburg versus New York to this case, because that was a brick and mortar store in porn access.
Yes, there's 2 cases that are sort of fighting each other here. Ginsburg versus New York. New York passed a law that said you can't sell pornography to children, to minors. And this is in the days of brick and mortar, pornography shops or magazine shops that have the blacked out section, right? And this guy sold pornography to children. He was arrested, challenged his conviction, and the Supreme Court there said a law like this for a brick and mortar shop will survive if there's a reasonable basis for it, right?
Yeah.
Rational basis review. Now, that helps Texas on the one hand because Texas says, well, look, we're in a new age now. This is the internet age. Pornography is online. It's not magazines. It's videos. It's online. Yep. It's ubiquitous. You can get it through your video game consoles, through your computer, through your iPhone.
Yeah.
So this is just Ginsburg for the 21st century. Now, Justice Sotomayor and Justice Jackson tried to turn Ginsburg against them. And they said, okay, yeah, but in Ginsburg, the basis of the claim that the guy made to defend himself was that you can't draw a line between children and adults. The right to access pornography is just equal for them.
Yeah.
Where was I going with this, Jack? Tie this circle. I just lost my train of thought. Tie this circle off for me.
So the justices who were skeptical of Texas, and you're right, the most skeptical were definitely Sotomayor and Jackson, said that Ginsburg only talked about the First Amendment rights of children.
Yes, that's
right.
It does not have to do. And they seem to be right as a historic matter that Ginsburg tried to challenge his conviction by asserting the First Amendment rights of minors, kind of an odd thing, but maybe necessary under the circumstances.
Yeah.
And the court, especially back in a saner mid-century time, had a little problem rejecting this proposition that there is a fundamental First Amendment right for children to access pornography.
I would agree.
But what Jackson and Sotomayor seem to be troubled by now is, well, when the pornography cases come up now in the internet, as they so often do, and this would go back to the other case you're going to talk about, is it's the adults' rights, the adult First Amendment rights, and they say that Ginsburg had nothing to say about burdening adult First Amendment rights, but there's a tension there.
Right. And then that brings us to a case called Ashcroft. Is it Ashcroft 1 and Ashcroft 2? But
Yeah, and those came up quite a bit in oral arguments today.
so Ashcroft was in the 90s, dial-up internet age, and there was a very similar sort of age verification requirement for them. And the Supreme Court said, it's strict scrutiny, and this law fails, et cetera, et cetera. And Texas, and to a lesser extent the government, because the government sort of takes a middle ground here. Strict scrutiny applies, but we think some version of Texas's law, some version of age verification would pass. But they're sort of up against Ashcroft, but their response is that, look, we're in a new era, right? This was dial-up. This was like
completely
fuzzy dial-up images, right? We're talking about, videos, trillions of terabytes of videos, high-speed internet in your pocket. Like, that changes things.
As opposed to what Clarence Thomas called squiggly lines on cable TV, right?
Just how squiggly.
I have kids. I know what they try to do. I also had brothers growing up.
And the Chief Justice in particular latched on to this, and he's like, okay, does our doctrine change with technology? And Justice Gorsuch's point was like, no, but the way it applies does. And the question really is for the Chief Justice, do we change the level of scrutiny that applies in light of technology, or do we just change how we apply strict scrutiny in light of technology?
And what's the difference between those two?
What's the difference between these two? Because Justice Kagan was onto this. She said, look, you could grant, say, intermediate scrutiny, lower the level of scrutiny, but you've got a sort of slippery slope. Or if you apply strict scrutiny and just say, actually, this passes, you've just done the same thing, and does that create slippery slope arguments?
Right.
But where we're really wrestling with this case is on paper, all the justices are really being asked to do, with one caveat I'll get to in a minute, is decide what level of scrutiny applies.
Yeah. A decidedly sort of unsexy question at the heart of a case that is fairly salacious in terms of, what is actually being regulated here.
But no matter, even if they just stick to that strict question, what level of scrutiny applies, they have to give some explanation of why. Yeah. And they have to give, I suppose they don't have to, but they're going to want to give the lower courts some guidance about how to do that, which means sort of dabbling in application at least a little bit. It gets more complicated, though, because the pornographers have asked the Supreme Court to, I got to make sure I get the procedural position quite right, to, what is it, Jack? It's
I think it's to reinstate the preliminary injunction that was ordered by the district court.
A preliminary injunction. That's right. To restore the preliminary injunction. Now, preliminary injunctions
coming out of the Fifth Circuit, which was the lower court here. Yeah.
Well, the district court is the one that issued the preliminary injunction, right? So procedurally, a district court judge in Texas found in favor of the pornographers and said, it's a facial challenge. So they're bringing it. They had brought it originally before enforcement. Yeah. District court finds in favor of them on the likelihood of the merits. It's likely an unconstitutional burden on protected First Amendment speech. So he issues a preliminary injunction, means Texas cannot enforce the law. Texas appeals to the Fifth Circuit. Fifth Circuit first has an administrative stay in place to keep Texas from applying the law. Then when it looks at the merits, it votes 2-1. The three-judge panel votes 2-1 in Texas's favor. Yeah. And so Texas, at this point, gets to begin enforcing the law. So we actually had some instances of enforcement. Now the pornographers would like, among other things, for the Supreme Court to reinstate the original preliminary injunction.
Yeah. So why that complicates things is because if you want a preliminary injunction, one of the requirements you have to show a court is a likelihood of success on the merits.
Right.
So now, if you want a preliminary injunction, the court has to do two things now. It has to, A, pick a level of scrutiny, and then decide under that level of scrutiny whether you're likely to win or not. Yeah. Now, theoretically, the court could just decline and send that back to the lower courts, but the pornographers have asked them to do it, so that complicates things, and there's an impulse for them to give the lower courts some guidance. So it's not – Sotomayor kept interrupting Justice Alito when he tried to get into the application, and she kept saying this is at one point she said this is a tangent, but it's not clear that it is a tangent, right? Kavanaugh came back and brought this up, and he said, well, they want a PI, they want us to restore the PI. There's merits questions.
She's also the queen of tangents.
Yes.
So So that makes it complicated. It's not really obvious to me that the court can just like make this an abstract question of level of scrutiny. There may have to be a little bit more, which
I think so too. Yeah. I felt like, and you guys let me know if you agree, I think there are at least 5, possibly 6 justices to rule in Texas's favor. I mean, it was very clear to me. Sotomayor and Jackson are all about porn access and striking down the Texas law. Kagan, I think, was concerned about, if it's a broad, strict scrutiny analysis, would that have implication for other formal free speech or former free speech cases and their entire line of free speech cases? So what did you guys sense overall? Yes, no?
I think so. There is a lot of support, I think, for the idea that some version of what Texas did here can survive. Everybody concedes, even the pornographers concede that states have a interest in protecting children from pornography.
Yeah.
The fight really just seems to be about like whether what Texas did here works.
Yeah.
Again, where was I going with this?
Well,
so everybody agrees, right?
Yeah.
That there's an interest here, that surely somebody can do something, but what exactly that is? Oh, right, here's where I was going. This question, though, is complicated by, again, the facial nature of the challenge. So facial challenge is this law is coming down the pike.
Yeah.
There is no conceivable way in which it can be enforced constitutionally.
Yeah.
And I win. That means you've got a burden as the challenger to show that there's just no way that this law could possibly be constitutional. Texas comes back and says, well, you're making a lot of assumptions about how we're going to apply this law.
Yeah.
There are a lot of, you sort of listed this parade of horribles about age verification, but there are a lot of really reasonable ways you could do this, and you haven't given us a chance to show you how reasonable we're going to be.
Yeah.
That may be the way of at least giving Texas a little victory now and sort of letting the lower courts really flesh out the details. That may be the easiest way for the Supreme Court to
actually come down.
Yeah. What that would mean is that this case would probably come back to the Supreme Court in a couple years. But they do that all the time. And that kind of approach seems really in line, particularly with Justice Barrett's predilection to not jump out ahead of a case and just really step by step work the way through it.
Yeah.
So that's a possible way of getting there, I think.
Yeah. What's your impression, Jack? Where are you feeling?
Yeah, so I think on the vibes, you had a lot of justices who were just simply skeptical of the pornographers. It becomes a little complicated when you try to figure out how they're going to work themselves out of this mess. The will seems to be there, but they're going to be cautious about doing violence to the free speech precedent as it exists. Now, some of them even be a little embarrassed of the current state of it. They've suggested that the original Ashcroft decision, or maybe it was Ashcroft 2, I don't remember, because Ashcroft was a case that came up twice. So either in Ashcroft 1 or Ashcroft 2, there was some musing in the opinions as to how technology such as age verification would develop. And, Ashcroft is more than 20 years old now. And I think the justices are in some ways a little bit embarrassed. It's almost like Grutter and Gratz, right? Setting a kind of 20-year time frame for looking back at something, and 20 years hence they look back at what happened in this was the race-based affirmative action, and they look back at how little had changed in the world since they permitted this. And I think there's a similar sense of buyer's remorse, looking back and seeing one, just how internet porn has proliferated. Justice Barrett came in with this point very, very early that Ashcroft was a 2004 decision. The iPhone came out in 2007. Yeah. The prevalence has just exploded. And in the meantime, it seems like a lot of the privacy concerns, like we should be clear about what the pornographers are trying to vindicate here. It is First Amendment rights, but in a weird way, they're also here as like the defenders of privacy, defenders of their users' privacy.
Users' privacy.
And there's something just sort of weird about that. And I say weird because, as an internet company, it's their business to sort of scrutinize and surveil their users, collect their data precisely so it can be leveraged. Now, they're going to say, well, we're private entities and we're using it for commercial purposes, which are lawful, and all of that is unfortunately technically true.
Yeah.
But here they are talking about what they repeatedly call Texas a hostile regulator. A hostile regulator who is trying to stop not just children, but really wants adults to stop.
Yeah.
And, to hear Schaefer, the advocate for the pornographers, talk about it, you would have thought that Texas was basically the CCP, gathering information on pornography users for who knows what purpose, but something malign is clearly his suggestion, right? You have a hostile regulator, and Texas is somehow going to collect this, and they're going to sell it. That was suggested explicitly, or they're going to use it again for who knows what purpose to persecute adult pornography users in Texas.
That's exactly it.
The suggestion is a little bit unclear, but whatever the suggestion is, it's a malign one. There's something just disorienting about pornographers coming to assert online pornographers, especially asserting privacy rights when they want a one-way mirror on all their users here. Schaefer gets up there and he makes some of the concessions that he has to just to make his appearance there palatable. He does say the state has a compelling interest. He is insistent that there is some theoretically possible way that states can address this.
That's less burdensome on the free speech rights.
But for him, the possibility seems to be mostly abstract.
Yeah.
And it seems to be about catching states or any regulators. The federal government has tried this before. That's what Ashcroft was about COPA. And it seems about catching legislators at any and every level in this unwinnable bind of having to do enormous amounts of work. I mean, compromise is hard enough in any legislature, but having to do enormous amounts of work amongst themselves, reach the necessary compromises, and ensure that the burden is virtually not burden on pornography distribution. Let's be clear.
Yeah.
Industrial scale internet pornography distribution is virtually nil.
Yeah.
This is reconceptualizing burdens for the internet age. And if access can be immediate on the internet, then their view is that constitutionally it should be immediate.
Yeah.
So for him, he will make the concession. He did make the concession that there are theoretical possibilities, but to me, it's not clear that possibility is really anything more than theoretical for legislatures to actually thread the needle, get the law so perfectly tailored and honed and polished and whatever.
And this is exactly how we got to the position where the Supreme Court protects pornography as free speech, right?
Yeah.
The Supreme Court created the rule that obscenity is not protected free speech, and it's anything that violates community standards and lacks artistic value, et cetera. But all those requirements were so abstract that hardcore pornography, if that's not obscene, nothing is obscene.
That's exactly it.
And that's protected. So
and to quote Justice Alito today, I mean, does Pornhub offer essays, from William F. Buckley Jr.
And the lawyer the lawyer was trying to tell him that somewhere on the website are thoughtful essays about
women post hysterectomy enjoying sex. That was the actual essay.
Yeah,
that was
essays about how to enjoy sex after a hysterectomy, and that's somewhere on Pornhub.
Children are curious about hysterectomy.
Sure.
I mean, the physical enjoyment of
they
sex.
are.
I mean, that one nearly stopped me dead.
Surreal,
The hysterectomy essay. I mean, I'm not going to sit here and suggest that it's not a problem, but children reading about how to enjoy it.
That's exactly it. And according to the standard, right? According to community standards, it has to lack serious artistic literary value and appeal to the prurient interest. If Pornhub doesn't appeal to prurient interests, I don't know what does.
Well, were you listening when I think it might have been Gorsuch. Both Gorsuch and Alito had good moments. Well, a lot of them had good moments today. One of them,
spicy.
I think it was Gorsuch actually tried to walk Schaefer through this threshold.
Yeah.
Part of the Texas law is written such that a company, an online commercial entity, can be regulated under this law if at least a third of its content would be obscene as to minors.
Yeah.
And so Gorsuch goes through this exercise when he has Schaefer in front of him. Was like, okay, well, what percentage would be obscene for minors? And like a good advocate, Schaefer's like, I couldn't say. I don't really know. It's vast. It's a vast amount of content. I really couldn't know. He's like, well, you have some familiarity with what goes on. I mean, he's like, is it? Well, let's take Pornhub. Is it 50%? And he actually got Schaefer to concede like, yeah, it's probably at least 50%. He goes, how about 70? And he got this kind of soft concession. He goes, how about 90? So well, then we might be overstretching it. He's like, okay, so we're at least at 70.
Right.
It was hilarious.
Wonderful moment when at first before Gorsuch got him to concede anything, he's like, I don't know, and Gorsuch was like, well, these are your clients, don't you know then? And then he was like, okay, well, because in addition to the concession about like it's
Sir,
probably
have you
70%.
looked at Pornhub?
Well, right, this is the
it.
great concession. It's just as Gorsuch got the lawyer to either admit he doesn't know his clients or that he's looked at a heck of a lot of Pornhub.
That's exactly it.
It's legally irrelevant, but very amusing, right?
And bad in either event. All right, so fun trivia fact, Jack. I'm going to end with you. We're just talking about sort of your 6 degrees of separation.
Oh, it's a lot fewer than that.
To the lower court,
1 degree of separation.
to the lower court in this case, and also to the law firm whose attorney was arguing for Pornhub.
This puts me. I was never involved with the case.
No, of course he wasn't. But it's a fun trivia fact.
I'm not. I was never involved in this case at any level. I'm not violating any kind of attorney ethical canons that I'm aware of, and I beg forgiveness for the ones that I'm inadvertently. I at one time worked for the firm that is representing the Free Speech Coalition. This was several years ago.
Okay.
So, not with the particular office, but yeah, it's a little bit strange. Not one I would have tried desperately not to be assigned to. That case, it's an excellent firm, right? You don't
always get to pick the cases that are given to you.
You pay the top dollar if you're really going to get this up to the Supreme Court. So it's not an accident who they chose, and so that's a compliment of sorts. But yeah, it's a little bit strange that it's a firm I had worked for at one point that's doing this representation, and
And who did you clerk for as well?
I clerked for the lone dissent in the Fifth Circuit. So yeah, the Fifth Circuit I mentioned was the sort of middle procedural stop for this case, and they ruled in Texas's favor, but it was a 2-1 vote, and the one vote was my former judge.
But let me add here. Let me make a point in defense of the lawyers. Everybody needs a lawyer.
Yes.
Even pornographers.
Yes. They do.
Deserve the best lawyers they can get. Because, just like...
this is a tough argument.
It is, right? And just like the Nazis in the Skokie case, right?
Yes.
Somebody has to be there to stand up for the worst of the worst.
That's it.
And you hope that the law shakes out well in the end.
I will also say, again, you've outed me as like far too self-interested here for people to take my views on this seriously. But I went and read the full Fifth Circuit opinion. I wanted to know what the judges had said, and lower courts are bound. Right? They're bound by precedent, the state of precedent as it exists, and I thought that his explanation of precedent as it exists was, more than fair. I lament the fact that it can lead us to places like the one that we're in. And I think Judge and I might disagree on some of the value in the speech that is being protected here.
But the decision that he reached is not unreasonable at all.
Oh, no, not at all. This is his decision is not a departure, right? If anything, of course, I'm more sympathetic to the majority in that case, but they had to do some serious work to try and get around this precedent as it stands. So
that's right.
Yeah, I have some
the Supreme
weird
Court's to thank for that, frankly.
Sure. I mean, yeah. So I have some awkward connections to this case. It definitely doesn't shade the way I think about this, because the way I'm thinking about it is, is contrary to the way my old firm and my old boss do. But of course, their involvement in this is totally within the bounds of what's normal for our legal system. I mean, they are at the very worst just doing their jobs. I would say that both of them are doing their jobs rather well. But such as the dark cloud center of liberal society is that you find yourself defending things that can look indefensible.
That's it. Everyone has a right to zealous representation, even when they're the bad guys. Otherwise, the Constitution doesn't work for everybody as it should. So, gentlemen, it has been a pleasure. I always enjoy talking to you both because I have a good laugh both on and off the show. So thanks for joining me today. We'll be right back on Case in Point. That is it for this Thursday, January 16th episode of Case in Point. We are so glad that you joined us. We hope that you learned something, were entertained. Obviously, my colleagues Jack and GianCarlo have a lot to make me laugh. This is why I keep them around. But we're also hoping that you understand a little better why the law applies to you, the everyday person who doesn't necessarily have a law degree, but why the judiciary, the courts, and what happens in Congress is important to your life too. Be sure to follow us on X at Case in Point Pod and share this podcast, which is on every one of your podcast platforms, Rumble, Apple, Spotify, with friends of yours or family who could use a little law in their lives. And until then, friends, court is adjourned.